Welcome back, everybody, to our studies in wills and the administration of estates for the SQE module. This video is going to concern ourselves with the first question concerning the validity of wills, the first point concerning the validity of wills. And we're going to spend a good 2 or 3 videos looking at the idea here of capacity, sometimes defined here as testamentary capacity. Fundamentally, then, we're going to be examining the major requirement here. The idea of an individual, in order for them to create a will which is valid, they have to have the capacity to create a will. Now, the idea of capacity, then, is a very important one, and one that is different, a little bit different, to the ordinary statutory interpretation of capacity, which does create a little bit of an ambiguity within the law, something that we'll get to as time goes on here, and I'll examine in more detail. But fundamentally, the question that we're concerning ourselves with here is, what is testamentary capacity? What does it actually mean for somebody to have testamentary capacity? If I am a solicitor that is looking at the validity of a will, or if I'm a judge that is looking to concern themselves with the validity of a will, what kind of things am I examining when thinking about testamentary capacity? This concerns the idea of the validity of wills and codicils for the SQE specification, and ultimately the main test for the determination of whether or not a person has this testamentary capacity, whether or not they meet the first leg of requirements for the validity of a will. This test is found in the case of Banks and Goodfellow, a case from 1870. Now, in terms of extension material, let's have a look a little bit at the facts of this case. You don't need to know the facts of this case for any question, for any exam on the SQE specification. You don't really need to know the facts of any case for the SQE specification. You barely need to know many cases, really. But again, that's why it's extension material. And the reason why I'm trying to provide some analysis of case law as well, specifically facts, is because it gives you a better contextual understanding of not only what the rules are, but also why the rules are made, and also it gives you a better indication of being able to think about these cases in more detail. But ultimately, this case concerned the validity of the will of a certain John Banks. The will had been made in 1867 and stated that Banks's estate would be bequeathed to his nieces and his nephew. It was then challenged, the validity of this will was then challenged, and it was disputed whether or not Banks had the mental capacity to make the will at the time, in fact, in which the will was made. Now, ultimately, the conclusion of this case, the application of the law to these facts, which is all law essentially is, or all case law essentially is irrelevant to this question, because what the courts do in the ruling on this case is outline for us the test for determining testamentary capacity. The court set about establishing this test, and they say that a person who is making a will must, number one, understand the nature and the effect associated with making the will. Number two, have comprehension of the extent of the property they are disposing of. And number three, must be aware of those who could claim the property, i.e. those who have the ability to potentially make moral claims. Those are the 3 considerations that are required for thinking about testamentary capacity. And so ultimately, the general rule is then that a person must have testamentary capacity as defined by the previous case at the time that the will is being created and executed. Now, there is an exception to this, and the exception to this will be examined in the next lesson when thinking about the temporal nature of the will. This is the case of Parker and Felgate from 1883. We'll spend the next lesson exploring that case because it provides an interesting exception to the rule concerning the idea that in order for an individual to have testamentary capacity, they have to have met that test, have met those requirements at the time in which the will was being created. In terms of a little bit of extension material then, how does the Mental Capacity Act of 2005 enter into this conversation? Well, we see the passage of this legislation in 2005, and upon the passing of this legislation, it was assumed by most, even some judges and commentators, see Theobald on Wills, for example, their 17th edition, that the statutory test for determining mental capacity would replace this common law test that we see in Banks and Goodfellow. The case of Banks and Goodfellow is a case from the 1800s concerning testamentary capacity, and now we have this new shiny piece of legislation that is defined as the Mental Capacity Act and talks about capacity, mental capacity in a number of different circumstances. So it was just presumed that when we think about determining mental capacity, we are no longer going to be thinking about the case of Banks and Goodfellow, and instead we're going to start thinking about the test that is established by the Mental Capacity Act. Well, in reality, this is not the case. It has been undermined, this view has been undermined by the case law, albeit only at first instance. See, for example, Scammell and Farmer from 2008. A bit of extension and further reading for you to examine there. But this does raise the question then, because we have a definition of mental capacity in terms of testamentary capacity for Banks and Goodfellow. But now we also have this definition of mental capacity in the Mental Capacity Act of 2005. And it raises an interesting question about the issuance of statutory wills and the potential legal confusion that is associated with having two definitions. While in its generality then, the Mental Capacity Act does not replace the test that we establish in Banks and Goodfellow. Essentially, Banks and Goodfellow survives the Mental Capacity Act in terms of still being good law. The statutory test, though, does apply in cases which requires a determination of whether or not the court of protection has jurisdiction to order the execution of a will. It also means that if a testator does not have the mental capacity, a statutory will can be made, and it will be done under the auspices of the Mental Capacity Act 2005. Which raises some very interesting questions and a bit of a legal critique. And I want to cite to you here Theobald on Wills, the 19th edition, page 103, where they say, quote, "The fact that the two tests are not identical raises an unappealing possibility. Either the certain testators may be unable to be sure of making a valid will for themselves, yet unable to enlist the assistance of the Court of Protection, or less likely that a testator for whom the Court of Protection has made a statutory will could then validly revoke it and make a fresh will." It does leave a little bit of legal ambiguity. Now, this legal ambiguity in the sort of critique of the law section here is beyond the scope of what you need to know for the SQE, hence why we've put it here as extension material, but it is still a fascinating conversation that you might have, and if you are interested in wills and estates and wish to essentially dive into this more if you ever then go into practice, when you go into practice, this might be an interesting area in which you might want to study more.